Supreme Court of Texas. All persons having business before the Audible, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. Good morning. Welcome to the Supreme Court of Texas. We will hear argument in 3 cases this morning. The first case is 230808, Tenaris Bay City versus Ellisor from Harris County and the 14th Court of Appeals. Justice Huddle and Justice Young are not sitting in that case. The second case is 240162, Paxson versus American Oversight from Travis County and the 3rd Court of Appeals. Justice Sullivan is not sitting. The third case is 240424, In re Encore Electric Delivery Company, a mandamus petition from Harris County and the 14th Court of Appeals. And Justice Bland and Justice Young are not sitting in that case. The court has allotted 20 minutes for each side in each of the cases. We'll take a short break between the arguments, which can be viewed live online and will be available on the court's website later today. We're ready for argument in 230808, Tenaris Bay City versus Ellisor.
May it please the court, Mr. Litteral will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. Plaintiff's case fails for the most basic of reasons. They failed to adduce any evidence that Tenaris' conduct caused the flooding of their properties. The causation question here was far from simple. Plaintiffs alleged that increased water outflow from Tenaris' site caused their properties to flood. But the hydrological dynamics of that were complicated to say the least. The water would have had to cross intervening water courses, would have had to travel up to over a mile away, would have sometimes even had to go upstream. And of course, all of this was happening in the midst of the greatest rainfall event in the nation's history, Hurricane Harvey.
Isn't it true that while some of the homes were very far away and they were upstream and all that kind of thing, that some of the homes were not? And so would it be possible that causation was proven with regard to some and perhaps not others, especially in light of the fact that this particular area received much less rainfall during this hurricane than other areas, surrounding areas?
Ma'am, I'm going to take the last part of your question first, if I may, which is that the testimony in the case from plaintiff's expert meteorologist, Dr. Branscombe, he did have some testimony looking at 24-hour rainfall periods. And he said, look, based on a 24-hour rainfall period, Harvey was bad, but it wasn't that bad. But then,
at least in this area.
At least in this area, yes. But the important thing here is that, of course, Hurricane Harvey was not a 24-hour storm. It was a long event, and in this area, it was a 4-day weather event. And
so does the testimony that it was only a 20-year storm take into account all those 4 days?
That is for the 24-hour period. For the entirety 4-day period, this was the heaviest rainfall event on record in Van Vleck and Bay City. Plaintiff's own meteorological expert, Dr. Branscombe, testifies to this, 12 RR 111. So this was an unprecedented rainfall event, and so it's not surprising that you have an unprecedented level of flooding. If I could go back to the earlier part of your question, because I do want to...
But there's testimony that the flooding would have been controlled if the standards had been met.
Your Honor, I do not believe there is. Plaintiffs say that in their brief a few times, but the only actual evidence that plaintiffs have, or the only evidence that they tried to develop, was that Tenaris' conduct increased the water outflow. They did do analysis within the Tenaris site, looking at whether the drainage mechanisms within that site controlled the water outflow. But they stopped once they reached the boundary of the Tenaris site, and their expert who would have testified on this, Mr. Novak, his testimony is in tab 1 of your bench book. He says over and over again, I didn't do a general flooding analysis. I didn't do a specific flooding analysis. I didn't look at any upstream possible effects of the flooding. I didn't look at what the boundaries of the area might be that the outfall from the Tenaris site affected. So there is
So
absolutely
that gets
no,
us back to Justice Lehrman's question about, well, what if some of the houses are right next to the berm and some of them are upstream? How do we parse that out?
sure, so one, I think regardless of of where the houses are in the most significant rainfall event in the nation's history and in the heaviest 4-day event in this area, you're going to have some expert testimony that these houses wouldn't have flooded without any increased outfall, because again, this is an unprecedented rainfall event. You have to show but-for causation. Getting to the other part of your question, it is certainly possible that, it is, I guess, theoretically possible that you could have a case where some flooding, very, very simple, maybe you don't need expert testimony, maybe but-for causation is obvious. And then some of the other properties, not simple, you need expert testimony to show how all of that would
But there
would
was
work.
expert testimony here.
There was no expert testimony on
As to
but-for
the
causation.
specific places.
Or even generally, and their expert, Mr. Novak, was quite candid in what he did and did not do. He goes through what he would have to do to actually look at whether Tenaris's the outflow from the Tenaris site caused any flooding. And he says, I have to look at topographical maps, do these hydrographic models, all of this. And he says, I could have done that, but I did not. That's not what he was asked to do. And he says he didn't do a general analysis of the area, not a specific analysis, none of that at all. All they have is their testimony that there was increased outflow. Whether the plaintiff's properties would have flooded anyway, there's absolutely no evidence whatsoever on that. If I could go back to the expert testimony point, because really, in flooding cases, we're not arguing for a rule that you always have to have expert testimony or that you don't ever have to have expert testimony. Our position is that we just apply these well-established causation standards that we have under Texas law to this flooding case. And so the basic rule for expert testimony is it's required when an issue involves matters beyond a juror's common understanding. Again, some flooding cases, certainly possible that it's very straightforward. Let's say it's a clear day and someone opens up a fire hydrant in your yard, shoots water into your yard, your house floods. Probably don't need expert testimony there. There aren't a lot of other causes, and an eyewitness can testify as to what happened. But as you get into the more complicated flooding cases, you certainly do need expert testimony. I think one place to look here is this court's analysis in the City of Keller case. That involved claims that a new development and its drainage plan caused flooding to a certain area. Now, the court there was focused on the city's knowledge regarding whether that would cause flooding, but importantly, and I think very relevantly here, the court said that the flooding question involved scientific or technical issues requiring expert advice, and that calculating the effect of detention ponds and absorption in a grassy drainage ditch required hydrological formulas, computer models, and mathematical calculations.
Well, they had expert reports on the detention pond and whether it was all the facilities there and whether those were properly maintained and properly built and all of that. So it doesn't really seem like that's the question.
Well, within the Tenaris site, I would agree that they had expert reports looking at the drainage pond and the berm and the detention pond and all of that, all focused on whether there was increased outflow. But what it didn't have, right, is what that increased outflow did, which is very important, of course, because one, how water moves is an entire area of science, right? That's what the science of hydrology is all about, and that's presumably why plaintiffs had a hydrological expert. That hydrological expert simply did not try to undertake this analysis after saying that he could do it, simply wasn't asked to, did not do it. And that's complicated here, not just because of the having to flow upstream to some properties are very far away. On all the properties would have had to cross intervening water courses and be affected by those currents. And then, of course, we have all of these other confounding causes. We have the greatest rainfall event in the area's history and in the nation's history. We have upstream flooding, we have upstream rainfall that's also impacting this. And so with that, to show
So
but-for
would that
causation.
be, would that be like an expert challenge? I mean, if you're saying the expert didn't exclude probable alternative causes, it seems like that's a challenge to the expert's opinion rather than an evidentiary challenge.
Well, I think a few responses to that, Your Honor. One, if plaintiff's expert had tried to do this analysis and he had just done a bad job and there were all these analytical gaps, perhaps that would be more of a Robinson challenge. But here, plaintiff's expert just didn't try. It's not that plaintiff's expert did a bad job. Plaintiff's expert was quite clear that his analysis stopped at the boundary of the Tenaris site. I will say, even if plaintiff's expert had offered an opinion, depending on how much basis he gave for that still may not be a Robinson challenge. That could be a conclusory ipse dixit opinion. This court's opinion in City of San Antonio versus Pollock explains that when an expert offers an opinion without any basis, that's simply a conclusory opinion. It's no evidence on its face. But again, I don't think the court has to even get there just in the interest of providing a fulsome answer. If we look at the non-expert testimony plaintiffs offered, again, our position is that this isn't sufficient, but I think it kind of drives home the point about why all of this isn't sufficient. They talk about how their homes didn't flood before Tenaris built its facility. But that, of course, is a logical fallacy of post hoc ergo propter hoc. This court rejected that in the Jelinek versus Casas case. Merely because one event follows some other event doesn't mean that the earlier event caused the later event. More is needed to prove causation, and that is especially true here since Hurricane Harvey was the heaviest 4-day rainfall event in the area's history and the greatest rainfall event in the nation's history. There is a serious question of whether plaintiffs' homes would have flooded without any increased outflow at all from the Tenaris site, and only expert testimony can fill that gap. Plaintiffs also
The jury charge says, has approximate cause standard for nuisance and negligence, but a cause standard for the water code. Can you spin that out a little bit? What's the measuring stick we're using for the water code? Is it just but for causation, not proximate causation?
So it is at least but for causation, and I believe the jury charge says without which that it wouldn't have occurred. I'm pretty sure it has a but for causation question there. Proximate causation, we also believe is required.
For the water code?
In the water code.
So did you object to the jury charge?
We did.
But you're not arguing that
We
here.
did not raise that point in this court, correct? We believe the but-for causation, which is the same across all of plaintiffs' causes of action, is enough to dispose of them all. I could also talk briefly about Tarrant Regional Water District versus Gragg. There's a highlighted copy of this in tab 2 of the bench book. I bring this up because plaintiffs focus on this case so much, just to orient the court. This is a case about construction of a dam that discharges into the Trinity River. There's a ranch 8 miles downstream. The Trinity River bisects the ranch. Ranch owner claims that the dam's construction increased the severity of the flooding on his ranch. Now, this case is instructive for a few reasons. One, it confirms what I believe was already clear, but in case there was any question about but-for causation in flooding cases, it says Gragg was required to prove that the same damaging floods would not have occurred under the same heavy rainfall conditions had the dam not been constructed. And that's exactly the kind of but-for causation that plaintiffs need to show here, that their properties would not have flooded had there been no increased outflow from the Tenaris site. They didn't even attempt to do so.
Well, that was the expert's testimony, though. The discharges were higher in the post-Tenaris models, so his opinion was that Van Vleck would not have flooded during Harvey without the facility.
He said that the discharges were higher. Agree there. He had no analysis about the specific properties flooding, as I think
I understand your point. Well, he said Van Vleck would not have flooded, so I assume that means the whole city.
I understand what you're talking about, Your Honor. That testimony is pure conclusory ipse Dixit after the expert says,
Well, he's basing it on the higher discharges, so it's not ipsy dixit. Maybe you think there's a gap, but I mean, that's the basis that he's offering for that opinion, so why is that not sufficient?
well, because that's not an actual basis for an opinion. He had said over and over again, here's what I have to do to have a basis to say that this or that property floods.
Yeah, I understand your point. Let's set that to the
Okay.
side for a second, your point about the individual properties, and I understand that, and I think we've covered that pretty thoroughly. But his opinion was Van Vleck would not have flooded, and so can you help me with what the problem is? Why are you saying that that's conclusory when what he's offering to support that is the higher discharge in the post-Tenaris models?
Sure, so if I could go back to the City of San Antonio versus Pollock case just to set the stage, it's if no basis for the opinion is offered, or if the basis offered provides no support, the opinion is merely a conclusory statement and cannot be considered probative evidence. Here, the opinion that was offered was that the discharges were higher. And then he says, I believe he says the town floods or something like that.
Van Vleck would not have flooded without the facility,
Correct.
something like that.
And so there is no basis, or certainly no basis that provides support as to how that discharge affected Van Vleck at all. I will also add, not all the plaintiffs are in Van Vleck.
Right,
Some of them are in
and
Bay
I think
City
that's
too.
Justice Lehrman's question that we were talking about earlier.
I see my time is up. I'll reserve the remainder of my time for rebuttal.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Heggen will present argument for the respondent.
May it please the court. Despite what my friend to my left here says, this is an unusually simple case, an unusually isolated town, unusually uncomplicated facts in the case. If you see I have the court a couple of exhibits here, and the first one is the town, the piece of land here that is at issue. This has been there for, it's been under cultivation for over 80 years, a rice farm, then it was a turf farm. Mr. Milberger, the proprietor, described how amazingly absorbent it was. He was world famous for cultivating a particular kind of grass that had roots that went down 24 inches into the ground. Said there could be 9 inches of rain could fall on that land, and only 40% of it would have water on the surface.
Are you arguing that we should look at this differently with regard to some properties as opposed to others?
Well, Your Honor, I think it's in the context of the thing. We heard that this is, just because Tenaris is there, just because the flood happened after is no evidence. Well, the evidence is what difference Tenaris made that was there. It's not just that it was before, it's that in exhibit number 2, you can see the construction there. And their own witnesses described completely decimating the power of that land to absorb, hold, transfer. It would filter the water out of all 4 sides over a long period of time.
So if we agree with you about that, and there is evidence about that for sure, and then there's evidence from your expert that the discharges were higher once Tenaris was there, the question that we were discussing with your friend on the other side is what ties that to particular houses?
Well, in this case, we only had 4 houses that are the subject of the charge here. 3 of them are essentially, you can stand on Tenaris property and skip a stone to their house. They're unimpeded, there's nothing in between. There are no intervening water courses at all in this case, in the case that was presented to the jury. There are no intervening water courses, no other source of water. There was a little ditch that was historically would carry water from the north side down to the turf farm there.
Isn't it some of the property upstream?
Yes, Your Honor, and that is a good point here. We had expert testimony by Mr. Calcone, who's the Matagorda County person in charge of supervising this project here. And he warned them on 2 fronts. One was at Exhibit 3 here, since you brought that up. He said, you guys can't have your water pouring out here, because if you do, you're going to force water upstream into the neighborhood. Forcing water into the neighborhood is a definition of flooding. He had Keller-style actual notice to Tenaris. If you continue with the way you're doing it here, and this takes a little bit of deciphering, you can see the inlet on the inside of the detention pond. We're looking at the edge of the detention pond. And you can't see the flaps that are supposed to be there to keep the water that would just, the original design, it was just open. The water would just flow right out of the detention pond, so there wasn't really any detention. So you have to do something so when there's all the water outside, you keep your water in. Now, we have testimony of why that didn't work either, but you'll see this looks like jet engines there. Tenaris contrived to do a workaround to shoot water from hundreds of acres directly at the spot where they were instructed, if you pour water there, you're going to flood the neighborhood. And they did it anyway. And this you can see, and this was described on the back end here, that they had basically a lip so the water would pour out on the backside into this channel that they contrived, which went under the berm or through the berm there, and would carry water around exactly where they were told not to put it. Tenaris' attitude was, we're not going to be responsible for that. The berm itself kept the water off of the land that historically had come on, another factor that contributed to the flooding that they knew about. Tenaris was not going to be responsible for the water that came from across the road here, the new Milberger farm, let's say. That was water that historically had come onto that land and settled. It would seek refuge there. That was their responsibility under their plan. And Mr. Calcom, he said, you can't push this aside. It's part of your catchment. You have to deal with it. It's part of what you have to absorb and protect the town from. And Tenaris said, we're just not going to do it. And they didn't. On the south side, and you can see, you can just about see Mr. Ellisor's house. He was one of the four, in the charge there. His house actually looked out onto this new Milberger farm. He was a seventh generation person there who'd actually worked on those farms as a young man. So he was very aware of the absorptive natures and the causation there. In fact, Tenaris relied on him in their argument that this Milberger farm should somehow be responsible and be a third party. They said, this is a guy we can rely on his testimony. Now, in the same breath of the testimony that Tenaris relied on, he also said, now that Tenaris is here, this water has no place to go. Which is exactly what Mr. Calcomey said. It's what Mr. Hodges, the man who designed the drainage system, said. So the upstream flooding is directly, the causal link is established by the man who designed it, by the man who supervised it, both experts, by the man who lived there for 70 years and watched the water come and go. He was there during Hurricane Carla. During Hurricane Carla, the defense experts said 17 inches of rain fell in a 24-hour period for Carla. It was before records were well kept, but he knew that much. Now, in this case, the most we have is 9.5 inches in a 24-hour period. And this is the definition of what a 24-hour event is for the design of this thing here. There was nowhere near the 100-year event, again, by their experts' definition, it's a 15 inches in a 24-hour period. Only a little over 9 inches is what actually fell. Their design was supposed to be
the reason you're focusing on 24 hours, the other side says, well, if you look at all 4 days, there were a whole bunch of, this was a historic event. And so your response to that is?
Well, even the full day, and this is, their own expert, Ms. Trevino, for example, came and she said, the rain gauge data is the gold standard for historical rain gauge data. Tenaris was obligated to have a rain gauge on its site. They were required under a condition of their building permit to have a rain gauge on their site. They said, no, we didn't do it. We're just not going to be responsible for that. There was other testimony from the maintenance supervisor, Mr. Johnson, who said, yeah, we did. I looked at it during the storm. For whatever reason, Tenaris contrived to have that information not be available. But we have rain gauge data from West Columbia, 10 miles away. They had only 10.8 inches for the whole week. We had other rain gauge data from Palacios, 20 miles the other direction, only 9.8 inches for the whole week. Ms. Trevino said she could not find any rain gauge data within 30 miles of Van Vleck that was over 15 inches for the week. Now, in using radar band technology and hypotheses, the experts could raise that a little bit, maybe up to 20 inches for the week, which is still well within a 100-year event. And Tenaris was obligated, their plan was, on a 100-year event, there will be no water leaving our plant. And they failed at that. And one of the reasons is their detention ponds, which is the real thing that they built, that was the defensive mechanism, were never maintained. Their experts said you have to dredge them, you have to reform them after any substantial rain. And
Let me ask you, so I think that there was testimony from Novak that he could have performed an analysis that would have allowed him to link the facility to flooding to specific homes, but he didn't because he wasn't asked to. So what's the significance of that?
Well, the significance of that is that's an engineering exercise that you would give to a student. Tenaris never said, we're going to stop the flooding 2 blocks over. We're going to prevent this. Fluor never did this. Tenaris never did this. No expert in this case did any kind of analysis like that. It was a brilliant cross-examination. Mr. Buteau is a master here, but it's a masterpiece of misdirection. That has nothing to do with the real determinations in this case. And the determinations in this case is when you have,
I think that's what we're struggling with. Tell us why.
Why is, if you imagine a 6-inch giant sponge on a tabletop and you pour water on it, you can pour water all day and eventually it will start seeping out. If you replace that sponge with a cookie sheet and tilt it, when you pour water, it's going to go off. And that's what happened here. Tenaris transformed this massive sponge into a cookie sheet, and they aimed it at the town. Now, the detention ponds, if they had been designed properly, and they were not, but if they had been designed properly, they could have held the water. But for that to work, they would have to be maintained. And as their own experts said, they just didn't do it.
The jury clearly agreed with you that it was a cookie sheet rather than a 6-inch sponge, but then where did it go on the countertop from there, and why didn't your expert testify as to where it got to and how it got there? I think that's what we're trying to understand.
Certainly, and it can be manufactured to look as if that's a challenge, but when the water pours off into the neighborhood, everybody can understand what happened. The water is in a neighborhood that should not be in the neighborhood, that did not have to be in the neighborhood. And that's why we have, all of the people in the charge were people who had lived there bordering to that plot of land for 70 years. Mr. Ellisor on one corner, Miss Story on the other corner. Her backyard actually abutted the Tenaris property. She had watched that water come and go. They'd all been there for Hurricane Carla, which was a much heavier rain in that area, and there was no water in there. Van Vleck, in the 180 years of this town's history, 112 hurricanes have come across that area there. This is, again, testimony brought by the defendants here. 112 hurricanes, and never has there been water in the land. Now, something changed. Either there was a great change in the amount of water, which there wasn't by the testimony, or there was a dramatic change in the land, and we know there was. In the plans,
So
the design
let me ask it
engineer
another
said,
way. So I've got your picture here, and I think we can all see how if the water's coming out of these pipes, it's going to hit the drainage ditch right here. And what you're saying is then the water's going to back up towards the town. It sounds
that's
like.
that's not what I'm saying. That's what Mr. Calcomey, the Matagorda County engineer, said would happen and did happen. It's what Mr. Ellisor said did happen. It's what Mr. Milberger, the guy who owned the property, said did happen.
But what about I mean, can you explain to us, like, I understand that, it makes sense, sort of from a physics perspective, that if you block this, that water's gonna start to impound upstream, but what we are asking about is what helps us understand how much and how far, and whether your expert did, Mr. Novak, is there something in Mr. Novak's testimony we should look at for that, or are you saying we should only look at the other people that you mentioned?
Well, I think, we have all of the experts basically acknowledge that the property did flood. I mean, the water did run off of Tenaris. We saw the pictures of the water going over the road top, which is a 45.5-foot road top, when the water would flow over anything that was 43 feet. So we had water that was just flowing off of the property that should not have. The rain was not so great as to make that water flow off there, except for Tenaris's misdesign there. Mr. Novak.
Novak testified about that?
I'm sorry?
Mr. Novak testified about that?
Yes, he testified, they testified about, the lip that they formed in the back so that the water would go around to the side. And of course, the detention ponds could not function correctly because of the lack of maintenance in 4 years of heavy construction. Their expert again said, when debris gets into these flaps that are supposed to be part of the protection, they're not going to work either. And I think it's a logical inference that the flaps would have gathered some debris in the 4 years of no maintenance of the detention ponds.
So there was testimony that this was the largest flooding event ever. But what about these, you mentioned Hurricane Carla, for example. Was there testimony about, let's say, what was the next largest flooding event and what happened then and what was the differential between the two?
Well, yeah, I mean, there have been hurricanes that put water in, deep in Bay City. 1984, there was a hurricane that had 3 feet of water in the elementary school. Miss Franks and her husband helped rescue children from that. Hurricane Claudette had 43 inches of rain in a 24-hour period 18 miles away. No flooding there. There have been other events. Hurricane Claudette did put flooding in Bay City, in downtown Bay City. So there have been several events that have flooded Bay City, their neighbor just a mile away, 2 miles away. There have been, massive rain events there, but because they've been so isolated and so protected, there was never flooding in 180 years of this little town's history until Tenaris built their plant and didn't maintain their detention ponds.
So what do you do with our opinion in City of Keller, where we seem to suggest that, I feel it in my bones, or I remember the nor'easter of '84 or whatever. In Keller, it seemed like we said that we needed to know what the experts thought about this sort of thing, and that just looking at a picture or just having worked on the sod farm wasn't going to be enough. Can you distinguish Keller? Do we need to overrule it for you to win?
Oh, yeah. Well, no, you don't need to overrule Keller at all. Keller is a takings case, and the test there was actual knowledge of the city beforehand that the plans would do this. And so the test is completely different. The state of mind is different. Now, in a couple of cases here, I think that we satisfy that test because Tenaris knew that if they did what they did at the outlet here, they would flood the town by backing the water up, by preventing the water that had come from north of it onto the land as it historically had. So they had actual knowledge it would do that. And on the south side, which is the only, the supposed remote case, which is the Frankson's house, which is a kilometer. It's several hundred yards. It's a long way down there. That's on the south side where Mr. Calcomi had said, this a different scenario there. They had blocked off the drainage that had drained that whole 250 acres. It had come across the Tenaris property, and they blocked it off first thing. And Mr. Calcomi said, you guys can't do that. You got to fix it. And they kept stiff-arming him for years. In 2015, he wrote him an email, said, guys, we have 3 feet of water back here flooding the back area here because you've blocked off the water. And that's just with the regular, weekly little rains. 3 feet of water had backed up there. They kept stiff-arming him. The Franksons are just in an exact line. They're the closest thing. There's nothing intervening. It's only that water backing up that flooded that house there. Now, Mr. Frankson, he grew up in that house. That's a house his father built. Again, his family sold Tenaris a little piece of their property there, but he abuts the area that Tenaris blocked off the land there. So even the Kerr test, the Keller test, would be satisfied there because they had actual knowledge that what they were doing was causing flooding, and they persisted. We're not going to be responsible for that water coming onto our property, was Tenaris's attitude. We will not be responsible. And unfortunately, was their attitude for all of this stuff. They're not going to be responsible for it. Mr. Pruitt, the district manager for the drainage district, said if we had known how resistant they were going to be to acting in good faith, we would never have granted this permit. This is, again, I guess you would call him an expert. He was on the county commissioner for 15 years, the manager of the drainage district for another 15 years. He also had a rain gauge, which was only 14 inches for the whole week, by the way. So the rain was not so extreme, really. Tenaris had the capability to disprove that if they'd wanted to bring forward the information they were required to have, and they didn't. And the majority of what they did was known beforehand by their own experts, by the people they were responsible to, and they just refused to engage that responsibility. We implore this court to have some responsibility on behalf of Tenaris.
Any further questions? Thank you, Mr. Heggen.
Justice Bland had her mouth open.
I did not.
No, okay. Just,
But I was
all
listening
right.
attentively.
Thank you very much.
Mr. Little, I believe you have 5 minutes.
Thank you, Your Honor. To clarify this rainfall rate evidence, just to be very, very clear, Dr. Branscombe, their own meteorologist, using his own rainfall data, said Hurricane Harvey was the heaviest 4-day rain event that he's aware of ever in Bay City and Van Vleck. That's 12 RR 111. He says more or less the same thing again at 12 RR 113.
But I don't know what that really proves. I mean, so it was the heaviest. But, if there were other rain events that were also heavy and this didn't happen, and the fact that it was constructed more like a cookie pan than a sponge, wouldn't that do it?
So, Your Honor, we aren't saying that the fact that it's the heaviest ever makes it impossible to prove causation or anything like that. We're merely saying that the fact that it's the heaviest ever means that you have to have some evidence that, look, even though this was an unprecedented rainfall event, these homes wouldn't have flooded without this increased outflow from Tenaris. And
Well, what about the Frankson's evidence that was just described about the drainage ditch had been blocked off and it was already, coming up quite a bit even with a regular rain? That seems to suggest that, if it's a really bad rain, it's really going to flood, but it's because it was blocked off.
So there were some complaints of some standing water on adjacent properties to the south, not impacting any of these plaintiffs' homes. How that's connected to this flooding, I don't think there's any evidence of. It's not even, I don't think there's evidence in this record that that's even Tenaris's responsibility. That's somewhat
Well,
disputed.
they said the person from the county said it was.
The drainage district, I want to be clear, the drainage district approved our drainage plan. It's not as if they didn't approve it and we just hauled off and it built this anyway. This was an approved drainage plan. There was a drainage complaint. There were communications with the drainage district about that complaint, but none of that still would
But
show.
that's not a defense, right, that it was approved?
It's not a complete defense, I think, in the type of as you're asking the question. My only point there is that there were insinuations in my friend on the other side's presentation that we were defying the drainage district and they were giving us all these warnings. We were telling them, no, we're just going to do what we want, and that's simply not what happened. Now, I don't think any of that really matters for the question here, because we aren't contesting, while we obviously maintain that we didn't breach any duties for purposes of this court, we're challenging the legal sufficiency of causation. And for that, we aren't asking for some insuperable standard that, no plaintiff could ever meet. We're simply asking them to give the expert testimony that their own expert said he could do. He said, look, I can do this hydrological model. I can back out the outflow from Tenaris and see what would have happened. He just didn't do it. That is
But
all
doesn't
that
that
we're
mean
asking
he
for.
thought he didn't need to?
Excuse
Doesn't
me,
that mean he thought he didn't need to?
Well, I think that means that he was not asked to do so. And I of course don't know what plaintiffs asked the expert to do and not, but for whatever reason, he looked a whole lot within the Tenaris site, said yes, there was some extra water flowing out, then he stopped his analysis. If I could address one more point, I don't think the court has to reach this, but in the event the court were to find that the evidence was sufficient for some homes and not others, the disposition is somewhat complicated here, so I want to flag it. This was a bifurcated trial, liability and damages. After the liability phase, Tenaris and plaintiffs had a stipulation that the total damages for all 3 zones was $2.8 million. If you knock out any one of those zones, that stipulation no longer operates because it wasn't as if Zone A is X, Zone B is Y, and Zone C is Z. It was an overall. So because you would no longer have the stipulation, and you also, of course, don't have any jury findings, you would have to remand for a new trial under Texas Rule of Appellate Procedure 44.1. You can't remand for a new trial solely on damages when the damages are unliquidated, which I think everyone agrees they are here, and where liability is contested, as it is here. So the disposition there, and again, I would urge the court not to reach that, but in the event it goes down that path, it would be a new trial on liability and damages for the zones on which the evidence was sufficient.
Further questions? Thank you, Mr. Little. Thank you to all counsel. The case is submitted and the court will take a brief recess.
Rise.